Welcome back to this already the final segment of today's Price of Business. I'm your host, Kevin Price, talking to you about you and your business. Continuing my conversation with Lee Kaplan, with Meisler, Kaplan and Veselka, a great law firm and a very unique firm that's now got 2 decades under its belt. And you can learn more about them at skd.com. Lee, before we talked during the first segment, you were talking about some interesting things going on in the relationship between lawyers and their clients. Why don't you go into a little bit about that?
Well, normally you should have a written engagement with a lawyer. And in that, it's usually a letter that comes from the lawyer that sets out the lawyer's view of his or her responsibilities and the client's views of your responsibilities. And obviously, there are times when an engagement leads to a dispute. The client feels that they're being overcharged for something, they don't want to pay for it, or they're upset about something the lawyer did that they think was not something they agreed to, whatever. And when you come to a dispute, what do you do about it? Assuming that the parties can't come to an agreement, then the possibilities exist that somebody will sue somebody else. And alternatively, you can go to arbitration. Many law firms now have arbitration clauses in their engagement letters, and they have for a number of years. And in general, those are enforceable, assuming that they're clear and that they are mutual. In other words, there's a real question whether an engagement letter that a law firm sends to somebody says, if you have any complaints about us, you have to go to arbitration, but we don't have to go to arbitration if we have complaints about you. And in fact, there's a case right now that's pending in the Texas Supreme Court that involves something like that. It involves a law firm called Royston Razor, a respected admiralty firm, in which essentially the law firm required the client to go to arbitration under the engagement letter, but the law firm was not so limited if, for example, it wanted to sue the client for fees. And the Supreme Court has agreed to look at this. I personally believe that that will be found unenforceable, that if you're going to have an arbitration clause in a lawyer-client relationship, it has to be mutual. That is, either side having a dispute has to arbitrate, or neither side arbitrates. So if I were a client, I would read the engagement letter very carefully and make sure you understand the arbitration clause if there is one. The other thing I would always look at in an engagement letter is the question of conflicts. Lawyers have certain ethical obligations regarding conflicts, and there is one kind of conflict that probably is not a conflict. It's what's called an issue conflict. And that is, there are times when, for example, my law firm might be hired to contest some kind of law, claiming that, say, the seatbelt law was unconstitutional. And that would be in one lawsuit between two parties, some kind of personal injury lawsuit. There might be a totally separate situation where I have another kind of client, maybe a client that manufactures seatbelts, and they might want that law to be held constitutional. While it would be wise of me to tell the potential second client about the other lawsuit, because it's embarrassing when your lawyers are inconsistent, that's more of an issue conflict as opposed to a direct conflict where you're representing one party in one case and you're representing another party who's adverse to them directly in another case. So it's important to understand what, if anything, the lawyers are saying about their obligations to you regarding conflicts. Those are the two things that I think are most important in engagement letters: arbitration clauses or not, and conflicts discussions.
Very interesting, very important. Let me ask you, how common in your experience, you've been an attorney now for quite some time, how common in your experience are these conflicts?
Conflict, the larger the law firm, the easier it is to have conflicts. Large law firms frequently represent companies that have a lot of lawsuits, and they have a lot of clients. And so conflicts are easy to arise, and lawyers have to be on the alert for them. But here's an example of a conflict that we had recently, or that we had to avoid. There's a group that owns a few companies, different kinds of companies. We are representing one of those companies in a lawsuit. We were then approached in a separate situation by someone who wanted to sue not the company we were representing, but another company that had this common ownership by, I think, a private equity group. And while technically that's not a conflict, because you would almost certainly be talking to some of the people that owned both companies, in one case or the other, we turned down the second representation because we thought that would be a conflict. It would create a problem. In the long run, I think it makes good business sense, even if you don't have to technically turn something like that down, to turn it down. You don't want to be adverse to people who you may be consulting with, but if they call the shots on one case, and be adverse to them in another case. So these kind of conflicts come up all the time, even for small law firms. And they can last for a while. If you represented somebody last year and the case is over, and you're approached the very next year to represent another company against the people you used to represent, if you have any secrets or confidential information about that prior client, then you should turn down the representation. And this is a lawyer obligation. Clients don't really think about these things. Sometimes they find out about them after the fact, and that's when everybody gets angry. So we all try to be careful about conflicts. We have computerized systems where we make searches before we take cases, but once in a while things turn up, particularly if another company acquires a company that you're representing during your representation. So you might be representing Company A, a large company, suing Company B. You've got a wholly separate lawsuit that you're handling for Company C, and then what do you find out? You find out that Company B has bought Company C, and now you've got a potential conflicts problem you've got to resolve. So these are things we just have to work around and pay attention to.
So that's interesting. I think it's really important for individuals to learn more about this. And so going to skv.com makes sense. Well, finally, let's talk about this HERO ordinance that continually is in the news with the last few minutes left. What do you have for us on that, Lee?
Well, that saga is not over by any means. And, in fact, we don't have a final ruling in the trial court. But if you remember when we last spoke, I predicted that having this jury trial was not the great victory that the opponents of the ordinance were hoping for. The jury apparently found that a number of the pages of the petitions were, in fact, improper. They weren't. Some of them had forgeries. Some of them were not properly signed, etc. Now, the people who oppose the law have said that the most important thing is that none of these 13 circulators of the petition in question submitted pages containing fraud. But that's not really the issue. The issue ultimately is, are there enough valid signatures? And I'm predicting that this court is going to find that there were not enough valid signatures. Now,
that's interesting.
And this is, I understand this is a Democratic judge, and a number of people have made some comments about that, but frankly, Judge Schaefer is somebody with a good reputation. I predict that he will find that the people supporting the referendum have fallen short. Then it will
I will say, it seems to me that he has gone, this judge has gone to lengths to be surprisingly fair, and every decision to date has favored the plaintiffs rather than the defendants, from what I can tell, at least every major controversy.
Well, in the vernacular, that's called giving people enough rope to hang themselves.
Yes,
I think he has been fair. It was a tough call as to whether they were even entitled to a jury trial, but he said, sure, you can have a jury trial. And I think the jury verdict leaves plenty of room for the court to find there were not the needed 17,000 some odd signatures.
Yeah, maybe the judge on Miracle on 42nd Street should have. Is that what that was called? He should have probably chosen the same route, right? Get a jury trial.
Right.
Let a jury decide this, right?
Well, I think ultimately the referendum effort will fail and it will be upheld on appeal. And I'm very aware that a number of the appellate judges, or maybe all of the appellate judges at both levels, are Republicans, but I do not believe that there will be a referendum over that ordinance.
Lee Kaplan, great guest as always. Learn more about him at skv.com. And this interview and so much more will be found over at the national news website, usdailyreview.com. Thanks so much, Lee.
Thank you. Enjoyed it.
When we come back tomorrow, we'll have much more for you. Do want to remind you, show continues 24/7 at priceofbusiness.com, and the best content here shows up over there at usdailyreview.com. Have a great day and spend it wisely on this station.